Okay, ladies and gentlemen, is this on? Okay. Okay, ladies and gentlemen, we're here today on the Scoggins Judiciary Subcommittee. Senate Bill 234. Senator Kennedy, if you will, tell us about the bill.
I will, Mr. Chairman. Thank you for making time for this to be heard. I appreciate you and your committee members being here today. I'm going to, as we were talking offline, I'm going to be brief and let some other folks mention this, but there's a little bit of history from the standpoint of we had this substantially the same bill last year. It's an effort to codify, if you will, some rules that we'll have in our laws for mediations for really three reasons. Number one, for legal consistency and clarity. Number two, to promote consumer protections through disclosures. And also number three, to enhance and maintain Georgia's leadership in the area. They can speak a lot more eloquently than I can as to what this would mean from a business development standpoint. Hey, afternoon, Judge. Yeah. For opportunities that our state is missing out on because we don't have this construct. And as I understand it, especially maybe with larger international mediation opportunities that are going to sister states around us, we'd love to come, for those good folks to come to Atlanta and bring that business this way. This is follows the Uniform Mediation Act, and so which comes from the Uniform Law Commission and the work that that commission does on an annual basis, not just with mediation bills, but other other proposed legislation that seemingly would be good if it were uniform across the country. That's sort of the source for this. The one other thing I'll say is we had a concern last year in House Judiciary with whether or not some language potentially could be construed as infringing on the otherwise sacrosanct confidentiality of mediations. Mm-hmm. Those concerns were addressed in some language that was added to the bill that I think are seen in lines 154 through 159. And Mr. Chairman, I am looking and working from LC 413029 Sierra is the document that I've got, and I hope that's the right one.
You said 149 through?
Lines on page 7, Mr. Chairman, 154 through 159.
Okay.
That language was added. So to put this in somewhat of a timeline context, what we had last year was the same as what we have here with the addition of lines 154 through 159, which I think is a reasonable approach. And to my understanding, all stakeholder, interested parties, people who had concerns before, the bar, these good people who really know about all this, everybody is pleased and supportive of this measure before you, and I appreciate you hearing us.
Okay. Any particular order you want your witnesses to?
I'll ask Mr. Sewell to please direct that.
Okay. What number you at? Okay, 3.
3.
Okay.
Okay. I don't know. I speak loud enough. Everybody hears me anyway. But as Senator Kennedy said, this was a bill that was here last year. It came right at the end, in our little June area, and toward the end we had some questions, and it wasn't necessarily, nobody was arguing about the need or the purpose. It was, we wanted to make sure, kind of like what happens in Las Vegas stays in Las Vegas. Right. We wanted to make sure what happens in a mediation stays in a mediation, and we worked very closely. A lot of it was with Jordan Reed, who used to be the aide before Evan to this committee. And we wordsmithed it, and as Senator Kennedy said, it's mainly in that section, making sure that we didn't change anything in the evidence code, also making sure that other things like there are mediations in the Open Records Act, that we're not changing those or doing anything like that. We've got a lot of compacts that have mediations in it. We just want to make sure we were doing this for this and nothing else. And I think everybody finds it to be a very acceptable and good bill now. And as I said before, Judge Barwick is the past chair of the Supreme Court's Commission on Dispute Resolution. She is here giving us moral support. We were a little worried when there's only 2 judges on the committee, Mr. Chairman, or both Mr. Chairmen, said that we needed another judge here. And so We have done that. Yeah, we've got North Georgia, we've got from the probate, the guardianship expert, and now, in Atlanta. And then Steve McKinney is really, one of the questions came up last year was, well, what do these mediation groups, the large mediation groups that a lot of people remember? Steve kind of serves both purposes. He's chair of the State Bar's dispute resolution section, but he's also a mediator. Is not full-time now because he's doing some other stuff that he's got to do, but works with some of the groups, and he can kind of talk from that end of as a mediator. But I just wanted to make sure he was here to answer any questions or
Okay.
give you just a little quick background on, what mediators go through.
Okay. Any questions for Mr. Sewell from any committee members? None? Okay. Mr. McKinney?
Yeah, Mr. Chairman, I'm on mic number 4.
4? Okay.
Mr. Chairman, if I could just briefly point out 4 points. One, the Georgia Uniform Mediation Act is focused on private mediations. We obviously have a court annexed mediation program that's accounted for in the code and it has its own rules. This act is going to provide for private mediations, which is the significant portions of the mediations that happen in the state of Georgia. The same kinds of structure for some important and key features that we have in court annexed mediation. So there's 3 points basically. One, it provides for privilege. Rusty has already pointed out that a key feature of mediation is making sure that there's transparency on the part of the parties with the mediator, even with one another if they choose to do that, and that transparency is underwritten by an understanding that what is communicated in the mediation is privileged. And it's hoped, in fact, in my experience as a mediator, it's absolutely critical that folks aren't candid and transparent in a way that gets disputes resolved if they have some sense that their sharing, even just privately with the mediator, is somehow or another going to prejudice them in some legacy litigation later or within the same dispute. The second feature, which is a brand new feature, and I think a very strong one, is that it provides some consumer protection in that it requires of the mediator that they disclose conflicts of interest so that the parties themselves have an opportunity to know, for instance, has this mediator worked hundreds of times with the lawyer for the other party? Well, has the mediator worked hundreds of times with my lawyer? So that we can really realize the ideal of mediation, which is to give the parties as much as possible the opportunity to take responsibility and take control of the dispute. And that should include taking some responsibility in selecting the mediator rather than ceding that responsibility entirely to their counsel. So we feel like that the conflict of interest provisions requiring the mediator to make those disclosures is a very positive step. Third, as the senator has so helpfully pointed out, there is a type of mediation that I'm involved in on a very regular basis that I typically call destination mediation. That is a dispute that is somewhere else in the world or somewhere else in the United States. And because of convenience and because of logistics, parties choose to basically fly in and utilize the service of a mediator and then fly back out. In my career, a commercial litigation career of about 32 years, I did a significant amount of that just by way of example in Chicago, just because it was so easy for folks to fly in and fly out, sometimes same day. Atlanta has a hard-earned reputation for sophistication. Certainly the airport provides us with a sensibility all over the world that Atlanta is a place that's easy to get to and get out of. And I think it works to our advantage here in Atlanta in particular, to have a statutory framework that gives comfort to parties overseas, parties in other parts of the United States, that there are rules in place in the code that define what the privilege is, that define what the obligations of disclosure are, rather than simply having to rely on a paper agreement between the parties as to how this is going to work, turning every one of these events into sort of a one-off situation.
Right.
Are there any questions I can answer?
I think Judge Gunter has a question. Judge?
Thank you, Mr. Chairman. Yeah, I had a question. You had mentioned about having to disclose, if you're a mediator, the number of mediations you've done with a particular attorney. Now that I'm a retired judge, I'm considering doing mediation.
Sure.
And I'm in a small town area where they do nothing but divorces, and there's just relatively few attorneys. So over time, I would amass a large number of mediations with a particular attorney or two. So, I mean, does that prevent me from being able to serve?
No, not in the least. And in fact, there is a feature that I find in mediation that when my party understands in trying to learn from me, if I'm the advocate, who the mediator is, what their credentials are, what their backgrounds are. One of the things that my clients are most interested in that situation is experience. Is this someone who's done a lot of this? Is this someone, for instance, who has practiced in the courts in this area and has a pretty good, or in your case, a very granular sense of how this is going to go down if we don't resolve this in mediation and go on to court? We have had situations where mediators end up being engaged because of relationships with counsel on a routine basis. And there hasn't been as good a job done on the part of the mediator to disclose potential conflicts with another party or with one of the other parties, which is critical information that one of the other parties needs to know. That's not to say that having disclosed the conflicts, that necessarily would cause one or the other of the parties to avoid or to do away with the engagement, but it just allows them to move forward on an informed basis.
Okay. All right. Thank you.
Okay, what number? 7? Okay, Chairman has a question.
Thank you, Mr. Chairman. Thank you, Senator, for bringing this important legislation, your work on this. And thank you, judges, Mr. Sewell as well, for all the testimony today. So great bill, very important issues that we're covering here, needed in our law. So I really applaud you. I was rereading the part that Senator Kennedy pointed out, this addition, lines 154 to 159, and deals with confidentiality. But I noticed that it's except to the extent there may be an agreement by the parties in writing. And I'm thinking of certainly in this post-COVID world where we're in, where mediation sessions are now being conducted by Zoom. You're not in the traditional framework where your parties all sign a piece of paper at the end of it if you reach an agreement. What the means by which you might satisfy that in writing requirement under those remote conditions. And if you may, run into a circumstance where, because you lack that, executed agreement when you walk out that you would traditionally have, that may run you into a circumstance where you need to get into what the nature of the agreement was that was reached at the mediation.
Right, and I apologize that I'm going to have some challenge in putting my finger right on it here in this instance. The legislation elsewhere includes an exception for disputes that arise relating to the substance of an agreement that is reached within the context of the mediation, if that makes sense. Not the dispute itself that you brought to the mediation, but dispute about some agreement that was reached within the mediation, typically to resolve the dispute. Certainly, all parties, to use sort of a common parlance, they want to have somebody to see about that. If in fact there is an agreement reached to resolve a dispute inside a mediation and someone isn't abiding by that agreement, or somehow or another that agreement isn't being executed in the way that this party understands the agreement was to have done that, they want to have the ability to put a record together for a judge, for instance, as to where that agreement came from and what the terms were. And so that is carved out as something that can take place. And the parties do have the ability to make use of information in the mediation itself to create a record that would inform how an agreement entered in the mediation was entered into and what its terms were.
That makes sense. And as I'm just thinking this through, would it be your view that if the parties had a remote mediation where just an email exchange occur with the specifics of the terms, that would satisfy the requirement that it's in writing regardless. So that would address this.
In
this
fact,
language here.
the reference to writing right here doesn't refer to the particular circumstance we've just talked about, but rather refers to the ability of the parties, if they choose to enter into a written agreement in the context of the mediation, to allow some information that was revealed in the mediation to be used with both parties' consent.
I see.
It doesn't happen that often, but there is an occasion where some information will be exchanged in a mediation and the parties will have a sense that it would make something work better afterwards, whether the dispute is settled or not, for that piece of information not to remain privileged. One of the key features of the private mediations we're talking about, I would say, frankly, in my own opinion, mediations generally, is that these are private exercises that ultimately the parties themselves can reach agreements about. With the passage of the GUMA, the parties won't be able to craft around the provisions of the statute other than the exceptions that are created within the statute. But what's referenced right here is a writing that the parties might enter into in the midst of a mediation that would allow them by agreement to allow certain specified pieces of information to be basically to waive the privilege as to those specific pieces of information.
Okay. Thank you.
Okay, any other questions for Mr. McKinney? Okay. Okay, Judge
I'd
Barwick.
just like to say thank you.
Okay.
I come as a proud representative of the dispute resolution.
Judge, can you move that
Okay, I'm
microphone
sorry.
over? Just swing it
Um,
around. There you go. Okay.
I'd just like to say, as a proud representative of the dispute resolution community, thank you so much for having us here today. And there are so many dedicated volunteers who've worked for so long to get this enacted. So we appreciate your taking it up. I'd also just like to say, sort of tangentially, that getting issues out ahead of time affecting impartiality or things that you might want people to know is protective. That's our words that we're using are protective and confidentiality. That's protective of everybody, so that it's not discovered later on and you start having a problem about it. So this is a good thing. And especially 65 counties in Georgia don't have court annexed programs. And so this is an effort to spread the protections that we enjoy. Thank you.
Well, thank you for your hard work. Any questions for the author? None. Okay. No other questions. Any other discussion from any amendments from anyone? At this point, I'll entertain a motion. Have a second. All in favor, say aye. All opposed? On the full committee.
Thank you, Mr. Chairman, and
Thank
thank
you.
you to the
Have a good
members.
day.
We appreciate
Thank you.
hearing us.
Thank you. Thank you so much. We appreciate it. Thank you. Y'all come
Thank
see
you,
us
Mr.
down
Chairman.
the
Thank you,
street.
Mr. Chairman. For this, okay. Great. Thank you.
I hope I see you
Oh,
soon.
man.
Thank